Hello, good morning and welcome everyone to the latest in our Pulse webinar series. My name's Paul Forman, International Sales and Technical Manager here at Novia Global, and delighted to be joined once again today by the team at QB Partners. With us today we've got Dave, Mike and Scott, who will be running through the main body of the presentation for us today. And the topic we're running through this morning is a question of domicile. So domicile is a key principle underpinning all international financial advice, with an individual's domicile status being fundamental in determining any potential liability to UK taxation. More so than ever before, clients are internationally mobile today. Therefore, it is essential to have a way of establishing which system of law and which country will govern questions around an individual's status and financial affairs. There is a lot of confusion, however, around the concept of domicile. So as such, taxpayers are wise to avoid any assumptions and also to seek expert advice to avoid any expensive and costly mistakes. Thus, we're leaving you in the capable hands of the team at QB Partners this morning to run through this concept. The slides will take approximately 30 minutes. We'll have 10 minutes or so at the end to run through any questions or queries. If you do have any queries, you can post them using the buttons along the bottom during the presentation, or alternatively, you can hold them back towards the end and we'll cover them off at the question and answer session. So without any further ado, I'll hand you over firstly to Mike from QB Partners. Thank you, Mike.
Thanks, Paul. Hello, everybody. I hope everyone's enjoying the warm weather. I actually live in the Republic of Ireland. I think it's been consistently this warm since the 1970s, but there you go. Maybe it's global warming. The business was established, QB Partners was established in 2009, fully independent. It was really created to help advisors and increasingly, so financial advisors, increasingly tax advisors and even product providers, to arrive at best outcomes for clients in the more complex cross-border situations. Initially, it was set up to cover international pensions, and then in 2017, the trust and estate planning pillar was set up, and that's where Scott sits. And then in 2019, we added a third pillar, which is international wealth insurance, which is my area of speciality. We are effectively, sorry, next slide, please, Steve. We are effectively an independent version of an international life co, I suppose, of their sort of technical office. But the key difference is that we deliver our support, our technical support in writing. We also have our own PI cover that backs the advice we give to the advisors. We do not give advice directly to clients, we advise the advisors. And although we don't give advice directly to the client, we do have something called a specialist advisor service for those occasions where the client's advisor can't, through maybe compliance issues, maybe the wrong jurisdiction, maybe there's a PI cover issue. We can step in and help facilitate the advice in that way. Enough about QB Partners. Let's now find out about some of our technical knowledge. I'm going to hand over now to Scott Hood, who will take you through the complexities and intricacies of domicile.
Morning. Thank you very much indeed, Mike. Thanks a lot. So when we're trying to help our clients understand their financial plans, then we often look at things such as legal characteristics. So we will look at, for example, date of birth. We want to make sure that any client that we're speaking with has the ability to do business with us, so contractual capacity. And we'll establish that through their date of birth. Date of birth will also rule out certain products, rule out certain solutions, that kind of thing. We'll understand their marital status, okay? We'll also understand their resident status, and we'll often spend a bit of time on that. But one of the things that's often one of the areas that's not often where there's not a lot of time spent is domicile. And that's usually okay, because it's usually obvious. It's usually obvious what somebody's domicile is. But in some cases, as we'll see, it's less obvious, and we do need to spend that time looking at it. So sorry, if I could move the slides on a few, please. Thanks. That's great. So what is domicile? Well, domicile is a legal concept. Fundamentally, it's a legal concept, and it's been used, however, as a link towards taxation. So it's fundamentally a legal concept, but it allows a link to a tax or taxes. In this presentation, what we're going to look at is the domicile from the point of view of the English and Welsh perspective, stroke UK perspective, and UK inheritance tax. Now, it's a much bigger subject than that, but this is an introductory session, so I think it's good to start with those two key points to start raising this with your clients. So it is a matter of general law. And because of that, so domicile determines which personal laws apply to somebody. So, for example, when dealing with a marriage or divorce or wills or succession, those kinds of issues, domicile will determine which laws come into play. Domicile is usually about your home country, your permanent home country. And as I say, for most people, that's pretty clear. But for some people, it won't be clear where their permanent home is. In addition, the concept of jurisdiction is different between different jurisdictions. We're going to focus today on the English and Welsh perspective, but in other countries, it may be different, and it will be different. So sorry, next slide, please. Thanks. So some basic principles then about domicile from an English and Welsh perspective. The first thing is everybody must have one. Okay, so there can't be a vacuum. There must be a domicile in place, but you can only have one at a time. Okay. In addition, if you want to change your domicile, or if you think you've changed your domicile, it's for the person, the individual who thinks that they've changed their domicile to prove it. It's the burden of proof is upon them to demonstrate that they really have changed that domicile. If we look forward then to some of the issues around the UK, then on the next slide, if I may. Thanks. So in the UK then, domicile aligns an individual with a specific legal territory. So in the UK, that gets interesting because the UK has 3 territories. We've got England and Wales, Northern Ireland, and Scotland. So technically, in a UK perspective, you don't really have a UK domicile as such. You have a domicile in England and Wales, Northern Ireland, or Scotland. However, for tax purposes, that's often grouped together as having a UK domicile. But it's really important when you're looking at a client and gathering information about them is to establish, if we're looking at the UK, which territory within the UK they are connected to. Just a reminder, of course, that the Isle of Man, Jersey, Guernsey are not part of the UK, and you could have a domicile in one of those 3 countries instead. So let's start at the very beginning, as the song says. If we start with an individual, an individual will have a domicile of origin. They usually acquire that from their father. So when the person is born, they take the domicile that their father had at the point that they were born, and that's their domicile of origin. That's unless the parents weren't married at the time of birth, in which case they'll take their mother's domicile at the time that the individual is born. And that's the domicile of origin, and that doesn't actually leave the person. It's always there. It's incredibly sticky. It's very hard to get rid of. Well, in a sense, you can't get rid of it. It's always there waiting to spring back into action. But if somebody wants to try to change their domicile, it's very difficult to do so because that domicile of origin has got a huge pull on them. One way of looking at it perhaps is a bit like an aeroplane. An aeroplane might take off. Whilst it's flying, it's in the air, but gravity is always looking to pull it back down to the ground again. And a domicile of origin is a bit like that. So where can people misunderstand this? Well, essentially, somebody might live outside of their home jurisdiction for many years, maybe 20, 30 years, but there may still be things that tie them to their domicile of origin. And because of that, they may believe that they're no longer, for example, UK domiciled in error. So if somebody's lived, say, 20, 30 years in another country, has perhaps worked there as well, but maybe there's a lingering connection with their home country. Maybe they want to retire there. Maybe they've still got a house there, something like that. They may not have actually acquired a new domicile in that country in which they've been living. So this can have a big impact, of course, because as I mentioned earlier, domicile is a hook for tax purposes, and UK inheritance tax in particular aligns to an individual's domicile. So if an individual has a UK domicile, then all of their worldwide assets are subject to UK inheritance tax. So it's a really important factor, and misunderstanding it could be very costly for an individual or their estate, their beneficiaries. Thanks. So in terms of domicile then, it does affect their exposure to UK inheritance tax, and that exposure has been increased recently in 2017. The scope of that has been widened still, fundamentally it's tax important. It's crucial to someone's tax position. So yeah. Basically, that's all I need to say on that. It's very, very important that someone understands what their domicile is from an inheritance tax perspective. Thanks. So here's a few examples. In this first example, then, we're looking at an estate of £500,000 sterling. We'll assume the client here has got a nil rate band, the deceased has got a nil rate band of £325,000. So £175,000 is subject here to UK inheritance tax if the individual has a UK domicile. We can see there then that's a tax bill of £70,000. Just for simplicity, we're not taking into account here of any additional exemptions or the resident nil rate band or anything like that, just to keep it straightforward. So here we can see an estate of £500,000 would give a UK domicile a tax liability on his death of £70,000 if that was the value of their worldwide estate. But as we'll see on the next slide, if we multiply that estate by a factor of 4, the tax bill actually goes up by a factor of almost 10. So for some people, this is a really significant issue for them that they may not be aware of if they're, for example, living abroad, have significant assets, but don't realise or understand their connection still to the UK. Okay. So what are the types of domiciles? There are 3 key types of domicile we need to be aware of. We've talked about domicile of origin, so that's the one that you acquire at birth and kind of stays there in the background until, well, basically for forever. However, you can acquire different types of domiciles. One is a domicile of dependence. An example of this would be, let's say a child is born to a father and a mother, and at the time of the child's birth, the father is domiciled in Scotland. Whilst the child is still young, the family moved to France, let's say, and they settle there, and the father acquires a domicile in France. Now, the domicile of dependency then for the child would go with that. So the child then would end up picking up a domicile, a French domicile, to go with their father whilst they're still a child. Another type of domicile we'll look at is a domicile of choice. So this is where somebody basically, well, we'll look, sorry, could we move to the next slide if that's okay? I think that's yeah, okay. So this is where somebody resides in another jurisdiction with a fixed intention to remain in that jurisdiction indefinitely or permanently. So it can be done. As I mentioned, the domicile of origin is very sticky, but the residence issue is relatively straightforward. You can usually judge whether somebody is resident in another country or not. They're physically there, and there's no real requirement for someone to be in a particular in another country for a particular time in order to acquire a domicile in that country. However, when it comes to intention, that's a lot more tricky, because how do you prove that intention? So we're looking to show that where somebody thinks they've acquired a domicile of choice is, well, what evidence is there? Because ultimately, domicile is a question for the courts, and they will want to look at the evidence. And it's very important, therefore, that if somebody is asserting that they have changed their domicile, that proof is there. And that might be in the form of, for example, having changed their nationality to the new jurisdiction. It might be that they've acquired property, land in that new jurisdiction. It might be that they've settled, had a family there. But those are the kinds of things that we can discuss with you, and you can discuss with your client. Even if somebody successfully acquires a new domicile, the story doesn't end there. So if we take somebody who was UK domiciled, domicile of origin in the UK, and they successfully acquire a domicile of choice in a country outside of the UK, they can still be deemed to be domiciled in the UK. Looking at the rule at the bottom, the 3-year rule. So somebody, even if they acquire a new domicile of choice in another jurisdiction, is still deemed to be UK domiciled for tax purposes for a further 3 years. This is inheritance tax now. So clearly that can have a big effect on someone if their worldwide estate is still subject to UK inheritance tax for the 3 years following them acquiring a new domicile. In addition, if somebody is resident in the UK for at least 15 out of the last 20 tax years, this rule changed a few years ago, they can be they will be deemed to be UK domiciled as well. So again, even if they've got an Australian domicile or whatever, if they're living in the UK, they've been resident in the UK for the last 15 out of 20 tax years, then they will be UK domiciled. Deemed UK domiciled. And finally, there's a new concept of formerly domiciled resident as well. So again, a relatively new concept, but this deals with people that were born in the UK with a UK domicile of origin who go back to the UK later. Even if they've acquired a different domicile of choice, again, they can be deemed to be domiciled in the UK. So it's very, very sticky from a general law point of view and also from a tax perspective. So what are the UK domicile implications? Well, really, from an advisor's perspective, it's important to understand where the person's assets stand. So, for example, if you've got a client with minimal assets, well, it might not be an issue for them anyway, because if their assets fall within the UK inheritance nil rate bands, then there might be no inheritance tax issue for them. However, issues to think about are, well, what if their value of their assets grow in the future, which we certainly hope they would do? What if their assets are already in excess of the current nil rate band, currently 325,000? Then they could be, or their estate could be subject to UK inheritance tax of 40%. Also to consider the position on second death. So even if one client has assets that's within the nil rate band, if they're going to leave everything to their UK domiciled spouse, or there'll be no inheritance tax, UK inheritance tax on first death, but they might be saving up a big bill for later on when the second spouse passes away. One thing to think about is that a lot of people that have a UK domicile, especially if they're internationally mobile, might not have a spouse who's got a UK domicile. That's really important because under the UK inheritance tax rules, there's a spousal exemption, which means that a UK domiciled spouse can pass assets free of inheritance tax to their UK domiciled spouse. If, however, they don't have a UK domiciled spouse because the spouse is domiciled somewhere else, there could be an inheritance tax charge on first death. So it's really important for advisors to understand the client's domicile and to review the IHT position and strategy. So let's look at a few plans then and how to plan for UK domiciled expats, because in the UK it can be relatively straightforward, but what's the position for people that are domiciled, who've lived abroad? Well, the first thing then is to establish that domicile. We at QP Partners can help you do that. The client might already have an idea, you might already have an idea to discuss that with them. It's obviously important to consider as part of your overall financial planning a plan for this aspect of their financial planning, and a major part of that is their wills. The wills can also be a bit of a giveaway as to where they're domiciled as well. You know, which laws have they made them in conjunction with. Really important to consider when planning for domicile is how much access a client wants with their capital, especially when looking at UK inheritance tax planning. Not many people can afford to give away all of the access to their capital. So again, it's very useful to understand where they are in that on that spectrum. They also might need to maintain control or discretion over who benefits from their capital. And it's often a good idea to keep the beneficiaries informed as to what's going on so that they've got the information at the time of death in order to deal with the advisors and the relevant tax authorities. Part of that, of course, is dealing with professional advisors who can help. So in terms of actual planning itself, if it's appropriate, a person with a UK domicile could consider a domicile of choice in another jurisdiction. As I mentioned, it's very sticky, it's hard to do, but it can be done. And I suppose that's where you need to have realistic chats with your clients as to what their aims and objectives are for their future plans. And if any of that for a UK expat includes returning to the UK, then acquiring a domicile of choice could be a problem, but it's something to be considered. If they are looking to consider a domicile of choice in another jurisdiction, then it's important to take into account the rules of succession in that jurisdiction and the extent to which they apply to the property that the person has. Because as we mentioned at the very start, this is a legal concept. So if someone has got a domicile of choice in a different jurisdiction, then their personal laws will apply to their succession. Obviously, the it's not important to take into account things like retirement objectives anyway as part of your normal financial planning, but even more so with domicile, because if the retirement objective involves living in a particular territory, that can affect their domicile planning. Trust planning, okay, I imagine you consider that anyway with your clients, but some jurisdictions more than others will appreciate an asset being in trust. So it's worth working out where they're going to retire and to what jurisdiction that's going to be as to whether trust planning is appropriate or not. And finally, of course, there's the option of life assurance being written in trust. So if somebody does have a significant inheritance tax liability on their estate as a result of being UK domiciled or deemed UK domiciled, there is the potential to do some life assurance to pay an inheritance tax bill. So broadly, that's where I'm looking to finish there. So Mike, over to you for a quick summary, if I may.
Probably helps if I unmute. Hopefully you can hear me now. Yeah, thanks, Scott. Really excellent presentation. I think for me, one of the important things that Scott's highlighted is building proof around supporting a domicile of choice. So if you really do want to move away from UK inheritance tax, it's really crucial that you and your client work out how to do that properly. Bearing in mind the legal decision is not really formalized until after the client's died. And building that sort of depth of proof is going to be absolutely crucial in defending that position if you are trying to get beyond UK inheritance tax. Scott and I have actually been working on a case recently where somebody has been, I think, resident in Isle of Man for nearly 20 years. And because they've got a sizable shareholding in a UK company, which they are in the process of selling, they will almost certainly still be deemed by HMRC as UK domicile. And until they sell that share in the shareholding in the company, and then they start a 3-year ticking clock, the chances are that if they die in that period, they will almost certainly be a UK domicile. So it is a very complex area of planning. It interacts with so much planning for clients who are internationally mobile. And as Scott said, QB partners can assist. We're easily accessible and easily contacted either via the website, through our emails, through phones, or indeed, please just ask Novia. We have a very strong and progressive partnership with Novia that's been going on a few years now. So if you can't be bothered looking us up, just ask the guys at Novia, and they'll point you in our direction quick enough. So thanks.
Thanks, Paul. Paul, can I just say a few words? We've got a few minutes.
Yeah, sure.
Just to add to that. So thanks to Scott and Mike. Morning, everybody. One thing I wanted to say is, this can be a very positive way of engaging with your expatriate clients, either with new clients or revisiting your relationship and adding value to existing clients, because what we've found when we've been talking about this subject is that it's amazing how many clients who live overseas, particularly those who've lived overseas for a long time, as Mike alluded to with the Isle of Man resident, they don't necessarily understand the concept of domicile, and they don't realise that they might still have UK domicile or English and Welsh domicile, sorry, Scott, or Scottish even. And that means that they still have a tie to the UK from a tax point of view, particularly from an inheritance tax point of view. So it's a great way of, if I dare saying, disturbing clients and making them think about this. And lots of clients, as I say, may not realise that they have this issue. They still have UK domicile. They have a UK inheritance tax issue in particular. And then once you've established that, that gives you a great hook to be able to sit down with the clients and say, well, now that we've established that you still have UK domicile, what are we going to do about it? How are we going to plan for it? You've lived in this country for 20 years, so you may be able to establish the proof that you now live in this country and that you have a domicile of choice in your new country. Or they might say, well, no, I am British. I'm going to go back to the UK at some point. I've still got a British passport. I want to maintain that. I don't want to do anything about that. It's not all about tax, and it's not all about tax. But in that case, then you can sit down with them and highlight their inheritance tax liability that they do have, and start to plan for that. So it's a great way of engaging. That's just the point I wanted to make. It's a great way of engaging with your clients and identifying new planning opportunities with them. Thanks, Paul.
Great stuff. Yeah, thanks, guys. All very useful stuff there. And I've got a couple of questions which were posed to me by people who can't make the webinar. They're going to take the recording in, but we have had a question posed today by Rob. It's just for the guys at QB to see whether you have any form of questionnaire or anything similar that would aid on this topic when doing IHT planning and discussing domicile and pertinent issues with clients.
Yeah, so certainly we do indeed have a questionnaire, and we also have an online questionnaire that can be used by advisors. So they can either just collect that information, send it over to us online, and that will enable us to help them with their domicile situations for their clients.
Great. So we'll discuss that offline, gents, to make sure that's readily available for all the delegates today. One of the questions I had posed beforehand was with regards to HMRC, whether you would be able to get an opinion from HMRC if you approach them directly, because obviously sometimes you may only find out whether it was successful when you're in your coffin and may not be around to see whether what you thought was true was actually the real event which occurred. So is there any scope to approach HMRC and get an opinion?
That's very difficult to obtain. HMRC are generally only interested when there's any tax at stake, and for most people that will only be after death. So it is near impossible to get an opinion along those lines, and that's where advice is really important. Even if HMRC were to give an opinion in any particular case, for example, if there was tax at stake, perhaps on a gift into a discretionary trust, they're likely to say that opinion was valid at the time it was given, but isn't necessarily going to be the same opinion that would stand maybe years later when the person's passed away. So it's very hard to get that opinion. That's why really expert advice is essential.
Great stuff.
I mean, I can add to that just from a practical experience. Dare I say, HMRC don't want to be particularly helpful with this sort of thing. It's not really in their interest to, and their sort of default position is that I think I'm right in saying, Scott, is that you still have your English domicile, and they're quite keen, particularly when there's a lot of inheritance tax at stake. So there's some examples of sort of very wealthy clients who've lived overseas for a long time, and on their death, there's been a discussion about what their domicile was, and HMRC, if there's a big enough inheritance tax pot to go after, will go after them. And there's been some court cases whereby there's been some dispute over domicile, and HMRC have actually sort of won and established that the client still has English domicile. So I think that's right. We got to take advice at the present point, and then what we were saying throughout the presentation was you can put the affairs in order of the client. You can document things in such a way as to show either that they have domicile in their country of residence, or to, as I say, establish that they do have an English domicile, for example, and that they've planned for that in such a way as to mitigate their known IHT liability.
Stuff. And one from another advisor, I talked in the intro about myths and assumptions. He told me about a story he had many years ago from a life office rep regarding Richard Burton. So for the kids in the audience, that was an actor from the 60s and the 70s. And he speaks to his clients and talks about the Richard Burton case, whereby he was deemed to be domiciled in the UK based on a Welsh flag being draped on his coffin as he was buried, and it revoked his Swiss domicile. Is that true, or has he been telling porkies for all these years?
Okay, so this case has got a great amount of myth and legend around it, but I think the bare truth of it is in there somewhere, and certainly it's Google it, I suppose, essentially, to have a good look at this story. The facts change depending on which report you read about it. But yes, there are stories about a Welsh flag being draped over his coffin. I'm speaking to you about 200 metres from the birthplace of Dylan Thomas. And one of the stories says that Richard Burton asked to be buried with a copy of Dylan Thomas's poems, and all of these things were seen to give him a link to Wales, to England and Wales, and therefore the UK. A recent report I read about this, or article I read about this, suggested it was around £2.5 million of inheritance tax that was due as a result. So please do have a look at that and use it with your clients.
There you go. Okay, I'll make sure that that one is researched properly and the key facts are explained. Great stuff. No, as always, guys, very enlightening. So thanks for your time this morning, and thanks everybody for dialing in this morning as well. We will be running this series on a regular basis. We already have topics lined up for August and September, including a session from the guys at QB again on estate planning and will writing, because that's been a very popular topic of conversation recently. So keep an eye out for the invites coming forwards there, as well as our Pulse newsletters. There will be a recording of today's session shared with everybody who registered, but also feel free to pass that on to your colleagues if you think that they'd be interested in this topic and it's useful for them as well. So with no further questions from the floor, I'd just like to wrap up and say thank you and see you all next time. Thank you.
Thank you.
Thanks, everyone.